Hi, I'm attorney Gregory Dell, and today I'm joined by attorney Cesar Gavidia, and we're going to discuss one of my least favorite disability insurance companies, which is Ohio National Insurance Company. And Cesar, I guess the reason I say that is because we've litigated against them so many times, and the experience has usually been challenging, although often at the end of the day it works out for the client, I would say, in my opinion. But this Ohio National sells individual disability policies, and they sell them mostly to business professionals, doctors, maybe a handful of dentists over the years. They've been around for a while, but they're a small company.
Yeah.
It's not a small company in terms of an insurance company. They're a small disability insurance company run by a handful of people who administer their claims. And actually, when I say they're my least favorite, the dynamic changed because I think within the last 18 months, DMS has actually taken over their claim handling because I don't think they were capable of doing it on their own in the in-house perspective. And of course, these are my own opinions from my own experience, so someone else may speak differently. DMS I have respect for as a company. We've been dealing with them for almost 20 years, and they do a pretty good job. So I think the future should be slightly brighter for claimants who have to deal with Ohio National. However, in this video, we're going to talk about the disability benefit denial options for someone who has been denied by Ohio National, let them know what they should expect, what our involvement is in a lawsuit, and what the potential outcomes can be of a lawsuit. So when a person first calls you and says, I was denied by Ohio National, what information are you going to need from that claimant in order to get started in helping them to get their benefits back?
Yeah, well, first and foremost, I'm definitely going to want to see the disability policy. That's a given, but also that denial letter. And maybe whatever correspondence leading up to that denial letter, because usually it's not like they've been going along, receiving benefits, and then one day, out of the blue, they just suddenly get a denial letter. There's usually been some sort of, stream of communication and correspondence with with Ohio National.
Right.
There's probably been some kind of, I wouldn't say hinting, but maybe more of an uptick in their questions, or they're getting this sense that things are a little different, and there's a medical review going on, or there's questions being asked of them concerning their activities, because maybe they've done surveillance recently or something like that. So I want to see the correspondence leading up to that ultimate denial letter, the denial letter, anything that they sent to the insurance company after they received that denial letter. Of course, attending physician forms, if they have those are those forms that their doctors have been completing and providing for them, because that'll give me an idea of what their medical workup has been in the past few months to a year. So those are the kind of critical things I'd like to see.
Okay. So when we talk about benefit denial options, a lot of people think I've been denied and I have to sue. Is that the only remedy that's available, and do you immediately jump into a lawsuit when dealing with an Ohio National disability denial?
If for whatever reason I believe that there's a reason we need to file a lawsuit right away, like there's a pending statute of limitations problem or something like that, then absolutely. I mean, there's no options left but to file that lawsuit immediately, just so that you could preserve that cause of action and recover your benefits. But I would do this kind of entire analysis of the claim, try to get as much information and documentation as I can from Ohio National. Usually they don't give you very much. You could ask for the file or anything like that, but they won't give it to you. Usually they'll give you, some bits and pieces of information, some recent correspondence, some things that you might have sent into them. They'll probably give you a copy of the policy if for some reason that's not, you don't have a full copy of that for whatever reason. But I do that because I want to see, is a lawsuit really the only option we have here? Is it ready for a lawsuit? Because maybe there's been some issue in the recent past, maybe not sufficient medical workup, the claimant hasn't seen their doctor
Right.
enough, or the doctor's support really is questionable or waffly. If that's the case, then we may need to do some more workup. We may have to have this person seen by some of our own experts, some of our own consultants, and do some things so that we could potentially avoid having to go to litigation, or possibly get the claim turned around altogether and get it reinstated.
Have you had success in taking a claim that was denied, doing an additional workup, submitting basically what we call kind of like a quasi-appeal letter, and then getting benefits reinstated for a claimant with Ohio National?
With Ohio National, I have. I mean, it's not, always the case. I don't want anyone to think like, oh, well, I could just hire these guys and they're going to get my claim overturned. I mean, the way I see it sometimes is that workup serves a dual purpose. Of course, we're trying to seek reinstatement of your benefits and trying to avoid having to go to a lawsuit and prolonged period of time of you going without any financial income. But also, if we do have to go to litigation, we have sufficient ammunition and firepower to go after Ohio National. They're not going to go down easy if we have to sue them. They're going to fight. Right. They're going to kick and they're going to scream and they're going to try to do everything they can to try to avoid losing that case. All right. So we need to be prepared, and that may require some additional workup before we file a lawsuit.
Right, and the additional workup's great because it puts the claimant in a better position to have more evidence to present once the litigation gets going. And also that process usually can be anywhere from 6 weeks to 3 months of additional time, and people may think, oh, I gotta wait another 6 weeks to 3 months, but we're gonna get into in a minute about litigation time frames. 6 weeks to 3 months is really barely any time at all in terms of trying to get another last-ditch attempt to try to get benefits reinstated rather than going through the prolonged litigation process. So let's segue into what the expectation should be for a claimant who has already tried all the other options and the only thing left to do is file a lawsuit. What should the person expect in terms of timeframes? And then let's also talk a little bit about the process and what type of burden is going to be on the claimant in terms of their involvement for what they're going to have to do throughout the process.
The fact of the matter is that the claimant's not going to have to do all of that much. They may have to participate in a preparation with us for their deposition. That'll take maybe a day or so. Their deposition certainly will take probably about a day. And there are going to be some other things that they may have to participate in, like mediation. That's when the court requires both sides to get together, sit down, and try to reach a compromise. But everything else in terms of the discovery that's involved, where we send out requests for production, interrogatories, and the different tools that we use to investigate the insurance company's conduct and the claim denial itself through subpoenas and things like that, and our own depositions, that's all of that we do. We're sit on the court's time frame. Well, I should say their docket, their scheduling order, and that scheduling order can vary depending on the court. So, I mean, there's cases that can be set as soon as a year for your trial date, and other courts may set it out 2-3 years, just depending on how busy they are.
And in terms of how long someone should expect until you get to the point where maybe there's going to be some kind of settlement offer, or all the way up until the time you can get to a jury trial? What do you think it would be time frame wise?
Like I said, every court is different, but in some cases it could take 12 months up to 24 months to really see yourself in front of that jury and get your day in court. It's dictated. Each court sets their own scheduling order. Right. So, but in most cases right now, what I've been seeing is anywhere from 12 months to 2 years. And unfortunately, in the kind of state of the pandemic that we're in right now, the courts are extremely backlogged. So it's taking time. But that doesn't mean that we don't have other things that we need to do, and we take advantage of that time to really delve in and do our discovery. There's also mediation that we're going to get involved in, and the court's going to usually order that. That's when we sit down with them, and they'll be with their lawyer, you'll be with your lawyer, and there's going to be another mediator there, and it's set for the purpose of trying to reach a compromise and resolve it without having to wait a year to 2 years to see your date in court.
So I want to clarify for people, because a lot of claimants don't understand what they're getting by filing a lawsuit and if you win. So if you can go through what the end result can be, and then what happens if you win after the trial.
Okay, so if let's say we get to trial, mm-hmm. and you prevail, what the court really what legally you can recover are those back benefits you're owed. Depending on each state, there's attorney's fees. That's a statutory thing. For example, in Florida, it's guaranteed first-party attorney's fees. If you sue an insurance company in a first-party action, which a disability insurance claim is, and you prevail, you'll recover attorney's fees. But after that, basically the court says, well, you're on your own. You got to go now to deal with this insurance company because I can't order them to pay your benefits indefinitely. Contractually, they have to go back and review your eligibility for benefits every single month. And that's what they'll do. They'll review you again, and could they ask for another medical examination in the future?
Right.
Yes, they can. Can they continue asking you for claim forms, doctor's forms, all of those things, and for you to continue meeting the eligibility requirements of the policy? Yeah, absolutely, they can do all of that.
So that's an important thing for people to understand, that just because you win doesn't mean you're on claim forever with no issues. You go back to where you were before, and you got to meet all the burdens continuing. The flip side to this, and super important point for people watching this video, is if you're denied, never stop paying your premiums. Explain why that's so important.
Yeah, that is really critical. And the reason for it is it doesn't necessarily invalidate your claim. However, I did find one policy that it did actually invalidate the claim when they stopped paying their premiums. So, in the abundance of caution, always continue paying your premiums, but the more important reason is you remain a liability on the books of the insurance company. Okay, what that means is if some intervening event happens, all right, and now you are totally disabled without question, or you have another claim that comes up, you could file it, you could refile it. And that is really a real significant thing in the eyes of the insurance company. You remain a liability on the books, and they remain liable for any potential claims that could occur in this period of time where you're fighting them on your original disability claim. The other thing is that I personally think it looks pretty good for our client to continue performing all of their obligations and responsibilities on their side with the policy. In other words, continue paying the premiums even after Ohio National's told them they're not going to honor their obligations under the policy. And they continue dutifully paying their premiums every month or every year, every 6 months, whatever it is. I think that really speaks volumes for someone that continues to do that.
Yeah, I mean, that clearly goes to the traditional argument to say, I paid the company and they don't want to uphold their end of the bargain.
Correct.
The other thing that I like, and that the insurance company always needs to know, is say, you, insurance company, you may win, Ohio National, you may win this trial, but guess what? Our client's medical condition over the past 2 years has gotten worse, and the day after this trial is over, he or she's filing another claim.
Right.
And you need to evaluate it. Because they continue to pay premiums, they're still your responsibility, and we'll go through this whole process again. So you're not getting rid of this claimant if they still
Right.
have the policy, regardless of, the standard may change to whether or not it was what their predisability occupation was, or is it the occupation of a retired person. So they say that's a little bit of a legal argument as to what the occupation would be.
Yeah, and in most places that defaults to any gainful occupation.
Right.
So what that means is that it's not like your policy just suddenly becomes worthless if you're not working in an occupation anymore and you're retired, so to speak. Now it usually in most places defaults to the Social Security standard of disability, that any occupation standard of the disability. So you still have value in that document you bought.
All right, the last issue I want you to cover is these cases typically resolve in what's called a lump sum settlement. Can you explain what that is and what it means?
Right. So in most of these cases, I mean, both sides usually just want to be divorced and done with each other, both Ohio National and the claimant. It hasn't been a great experience, so to speak, if they're dealing with a denial of benefits, and our clients, typically feel that they're entitled to these benefits, and they strongly feel that way. So why would they trust Ohio National to continue doing the right thing even if they overturn their decision? They kind of understand this is going to be an ongoing process with them, and they're going to have to continue to fight for these benefits if they want them. So what's a common thing is for a global lump sum settlement to occur, and that's basically where a compromise is reached on the back benefits that are owed to them, and there's a valuation process that's done, an actuarial valuation of the future benefits that's done to determine kind of the value of the entire claim. And we negotiate within those parameters, within those numbers.
And so whatever that number comes out to, at the end of the day, I always tell people it becomes a business decision, because let's assume your policy is worth $1 million and they offer you $400,000. You as the claimant need to make the determination, do I want to risk a guaranteed $400,000 to possibly get $1 million?
Yeah.
These are not indicative of what offers are. It's just that becomes a business decision. There's hard money on the table, you can take it, be done, your policy's over, you surrender it, you can go do whatever you want after that. Both sides are free to do anything, it's over. Or do you try to roll the dice and go to trial and see if you can get more money?
Right.
So that's a business decision the claimant has to make. The important thing is that the claimant makes that decision. I mean, we just give our advice as to what we think the chances of success are, and we obviously do whatever the claimant wants. We're always, not always, but if you want to go the distance, you should feel comfortable that we know how to do it, we've done it before, and we'll do everything we can, but it's up to 6 people, being the jury, who you've never met in your life, to make that determination as to whether or not you're entitled to benefits. It's not going to be a judge decision, it's going to be a jury decision in almost all of the Ohio National disability policies. So no matter what stage your claim is at, if you've been denied or you're concerned you're going to be denied, reach out to either Cesar, myself, any of our disability lawyers. No matter where you live in the country, we're available to assist you. We've filed these cases against Ohio National all over the country. Our last case, lawsuit filed against them, was as far away as Hawaii. So no matter where you live, that's not an issue for us to help you, and we welcome the opportunity to discuss your claim with you. We ask you to submit a free consultation request on our website, and then we'll ask you to email us your denial letter, or you can go ahead and call us now, and any of our disability lawyers will answer your call. We also encourage you to spend a little bit of time on our website. Search Ohio National, search your medical condition, search your occupation. You're going to find a lot of helpful information that's going to educate you about this disability insurance process. It's very important for you to know as much as possible and learn to think like Ohio National does, because the better educated you are, the better chance you're going to have of getting your benefits approved. So we welcome the opportunity to speak with you, and we'll be here in the future should you need us.